There are three key elements that every plaintiff must show if they would like to seek a preliminary injunction and obtain one before a court. Number one, the plaintiff must show that there's a likelihood of success on the merits of their claims. Number two, the plaintiff needs to show irreparable harm. Number three, the plaintiff needs to show that a balancing of equities is in their favor. And number four, the plaintiff will often argue or should argue that they should not be required to post bond even if their preliminary injunction order is granted. Now, most of the time, if you're getting an injunction, it usually means you're going to have to post bond, but it always makes sense to make the argument as to why you should not have to. And now, let's dive into the details of those elements so that we can see how we can establish and obtain a preliminary injunction. To establish a likelihood of success on the merits of claims, the plaintiff needs to first set forth theories that they're trying to prove and intend to prove at trial. So, for example, the plaintiff will set forth all of the elements required to establish a claim for fraud, a claim for breaches of fiduciary duties, a claim for corporate waste, claims for unjust enrichment, etc., etc. The next step is the plaintiff will then perform a factual analysis and tie facts to those legal claims so that they can show that there's a high likelihood they'll be able to satisfy those elements at trial. Now, in addition to the facts and in addition to the legal theories, the plaintiff will then want to use a lot of documentary evidence and support to show that there's actual proof to justify why it is they're seeking the relief that they're seeking. Emails, contracts, bank statements, anything that you can show to the court that will show that there's a high likelihood that the allegations you're claiming happened actually did. You'll also want to have credible witnesses through the forms of affidavits. Affidavits are sworn statements by witnesses who can attest to what's transpired. Beyond that, you're also going to want to utilize case law. Case law is a means by which you're citing various cases of the law that show that based on everything that's taken place, you believe that you'd likely win in an outcome of these matters.